What I have for you today is an interesting case on tax resident about the gentleman you see in the background, Jonathon Oppenheimer, who is part of the Oppenheimer dynasty, who started and owned De Beers diamond mines and then sold it to Anglo-American, and is one of the more rich families in the world, to put it mildly. So let's look at the case. It is from the UK Upper Tier Tribunal, decided in August, I believe, in 23. And the question was whether Mr. Oppenheimer was a tax resident of the UK or of South Africa for tax treaty purposes. And a whole lot of complexity involves. If we look at the timeline, we're talking about the years from 2010 to 2017, the UK tax year, so 2010, 11, and then 17, 18, I believe, or 16, 7, I'm not sure, in which he was taxed in the UK. Now, important was that De Beers was sold to Anglo in 2012, and it's an interesting connection because one of the oldest cases I discuss on my channel is the De Beers diamond mine case and the tax residence of that company from 1906. And you can find the link here and in below to that case. Now, spoiler alert, unlike the De Beers company, which was found to be tax resident in the UK, Jonathon Oppenheimer was not, but the reasons were quite interesting. The amount of taxes involved, the UK said that he remitted £20 million to the UK because he was a resident non-dom, and that led to an additional tax assessment of 10 million. He already declared other income taxes in the UK. Now, if we look at the connection points, because this is what it's all about. If we look at South Africa, he was a resident. He was a resident in South Africa, and he had a permanent home in South Africa. All the yellow text is what the tax authorities and Jonathon agreed on. And the tax inspector, the UK tax inspector, said there's an undoubted love and loyalty for South Africa. The majority of his family was there. He attended all major family events there. He did a lot of philanthropy, politics, and culture there, together with his wife. He voted in South Africa. His private doctor and dentist was in South Africa. He had apparently an incredible farm on Isibindi Farm. He also owned a house on Leopard Creek Golf Estate, and the judge was not quite convinced that he also had the Tswaru Farm because it seems that there were more mixed interests involved there. But most important for this case, he was a South African citizen. Now, for the UK, he also had a resident and a permanent home. He was also resident in the UK under UK law, not under the treaty, and had a permanent home in the UK. He had an habitual abode in the UK. And the question was whether he had an habitual abode in South Africa. His dad was resident in the UK until 2013 when they sold De Beers to Anglo, and the dad moved back to South Africa, and his first and third children went to school in the UK. And this was important because he basically moved to the UK to be with his children while they were at school. He never voted in the UK. He had several London flats in the UK and again a magnificent farm called Folly Farm in the UK, where he spent most of his time during most years. Although he did not have UK citizenship, he did have a UK permanent residence. And then there were connections with the US. His wife was American. Their middle child went to school on and off in the US between 11 and 16. They had several apartments spread over several cities in the US. And from 2012 onwards, when they sold De Beers, about 70% of the family capital were managed in and from the US. And then he had an involvement in a lot of African countries and Asian countries, which should be mentioned here as well. One interesting point is his wife unfortunately died in 2017. She went to the US for some treatment, I believe, and then came to the UK, and that's where she died, and she was buried in the UK. But if you look at the funerals, you know, there were three separate funerals. There were 200 people at a US funeral, 330 at the UK funeral, and 1,000 in South Africa. And these numbers are significant because the judge also later refers to them in terms of social and economic connections. And then a last point about the facts of the residence. This is an interesting one. The judge says, as we've indicated, Mr. Oppenheimer has chosen not to provide the tribunal with details of his movements for all the years with which we are concerned, although those records do exist. Now this is interesting from 2 points of view. The first is, if you look at the amount of personal data which is published about Oppenheimer in this case, it is phenomenal. I don't think any private person wants that much data about them in the public domain. On the other hand, if you look at cases that I've discussed on this channel, like Tetra Pak, you know that if you pull a trick like this in Denmark, if you do not give the judges and the tax authorities the information they ask for, your chances of losing your case has more or less tripled, right? So the judge complains about this, but goes on being, I guess, trying to be as objective as possible. So if we look at the days that he spent everywhere, and they only had a couple of years, they didn't have all the years involved, but you can see he's in 2009-10, he still spent a significant amount in South Africa, but far more in the UK, and that number only gets worse down the line. But more important, you can see although he spends a lot of days in the UK, he also spends a lot of days outside of the UK, more or less half the year, and sometimes more. So these were the facts on which it was to be decided whether Jonathon was a tax resident under the treaty in South Africa or in the UK. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. So let us look at the technical aspects of this case. And we start with Article 4 of the treaty. Now 4.1 is nothing special. It says, for the purpose of convention of the resident of a conquering state, means any person under the laws of the state that's liable to tax by reason of that person's domicile, residence, etc. Right? And then we get to paragraph 2, and this is what it's all about, tiebreaker. Where by reason of the provision of paragraph 1 of this article, an individual is a resident of both contracting states, which he was, then the individual's status shall be determined in accordance with the following rules. And if we look at paragraph A, the individual shall be deemed to be a resident solely of the contracting state in which he has a permanent home. Now clearly Oppenheimer had several homes in both states, so this do not help because they were all permanent. And then you go further and it says, if a permanent home is available to the individual in both states, the individual shall be deemed to be a resident solely of the state with which the individual's personal and economic relations are closer, or as we call it, the center of vital interest. Now remember, his extended family lived in South Africa, but his wife and his children basically lived with him in the UK, right? So this is a bit of a problem. He spent most of his time in the UK. So things do not look good for him, but if he passed the center of vital interest test and he have a center of vital interest in both states, then we need to go to habitual abode. If the sole residence cannot be determined under the provision of paragraph A, the individual shall be deemed to be a resident solely of the state in which he has an habitual abode. Now, it was already agreed that he had an habitual abode in the UK. The question was whether he had an habitual abode in South Africa, considering the fact that he was not there that often and it became a little sporadic, right? And if he did have an habitual abode in both states, then it was quite clear that he was taxable in South Africa because he was a South African citizen, not a UK citizen, right? If the individual has an habitual abode in both contracting states or in neither of them, the individual shall be deemed to be a resident solely of the state of which the individual is a national. So let's see what the court decided. But before we do, the court makes some interesting comments on treaty interpretation. First, it said the treaty must be interpreted in accordance with the Articles 31 and 32 of the Vienna Convention on the Law of Treaties. Wonderful to see a judge start with that when they interpret the treaties, right? But then she also refers to the OECD, and she says the Republic of South Africa is not a member of the OECD, but the parties are agreed that both the RSA and the UK were aware of the commentary on the Model Convention. And quite frankly, I mean, South Africa is a very, very active participant at the OECD, so it'll be strange to say that one could not apply the OECD commentaries. As a matter of fact, one can say that in large part through South Africa's doing, there are some significant parts in the transfer pricing guidelines on commodity trading, for instance, right? And then paragraph 28. Technically, this is a very interesting point because the UK goes off the OECD agenda here. It says technically the resort should be had to the commentary as in force at the date that the DTC, the double tax convention, was agreed. And then more recent versions only to the extent that they are cogent and assist to the determination of the tribunal. Now, the way I read the OECD commentaries, they say, the starting point is you can always apply the later commentaries because these are just explanations. These do not change the text of the commentaries unless the text of the treaty has changed itself in substance, not just in form, right? And then HMRC also rely on paragraph 62 of the UN commentary because South Africa is a signatory. And basically HMRC, it turns out, shot itself in the foot here because what paragraph 62 says is, it's not just about where the contract gets signed, but it's really about where the decisions are made. And it's not about where, but where the effect is, something to that extent. But obviously, great to see the UN commentaries being quoted in a UK court case. And you're considering the fact that one of the two countries is not a OECD member, very appropriate as well. What is interesting is the question, why did they not refer to Article 3.2? Because that's in the treaty, right? Article 3.2 says read the national law if something in the treaty is not defined. But if you think it through, but still some text would have been helpful from the judge here. 3.2 says look at the national law, and if you're going to define the term resident, whose national law should you apply? I mean, the treaty says you need to apply the national law of the country who applies the treaty. But that would be a bit of a perverse outcome in this case because surely both South Africa and the UK has definitions of residence under their national law, and this is exactly what the case is about. But it's an interesting sideline. Let's move on. The judge introduces a case and says, as long ago as 2017 at the meeting between Mr. Oppenheimer's advisors, the HMRC officer who was conducting the inquiry, and a Mr. Thomas of the UK Competent Authority Treaty Claims of Unit HMRC, Mr. Thomas, whose field of expert this is, so tax residents, confirmed that in his view the issues were finely balanced. HMRC confirmed that again and again on a number of occasions. So already the judge and the UK competent authorities, apparently the map didn't work, and HMRC said this is a complex case. And the judge then blasts both parties for saying, the lawyers on both sides are supposed to help me in coming to a decision. Instead, they've taken opposite points of the views and tried to contradict each other as much as possible, which is an interesting note aside. And then in 221, she says Mr. Stone, who presented the UK government, focused on the UK, fine details such as day counts and the absence thereof. Mr. Oppenheimer's immediate family, being his wife and children, not cousins and parents, etc. On the other hand, Mr. Goldberg focused on the Republic of South Africa and adopted a more broad brush approach. He looked at the Oppenheimer family in the wider sense, starting with Mr. Oppenheimer's great-grandfather, who started De Beers, Mr. Oppenheimer's entrenched roots within South Africa, the South Africa's place in Africa, because the HMRC said, he doesn't only do things in South Africa, he does in a lot of places in Africa, but it all emanates from South Africa, right? Mr. Oppenheimer's past and present commitment to and involvement in South Africa and Africa. And then right towards the end, the judge says something interesting about the commentaries, and I think that describes this case very well. She says, the examples given in the commentaries, the OECD ones, and in the cases, those were the ones to which the parties referred to UK court decisions, do not assist us greatly, since those were concerned with individuals whose lifestyles were infinitely less complex than that of Mr. Oppenheimer and his family. He lived and worked not only in the RSA, USA, and the UK, but also worked elsewhere in countries such as Luxembourg, Ireland, and other countries. And that's what makes this case so interesting is, a case about residence is normally pretty binary, but that's not the case with Oppenheimer. So Permanent home was quite clear it had in both states. So now the question was there a center of vital interest in both states, considering the fact that Oppenheimer spent most of his time in the UK and his wife and children were in the UK, right? Both Mr. Oppenheimer and his wife had a large number of close friends in South Africa. They also had an extended family in South Africa, including Mr. Oppenheimer's grandmother until she died in 2013. Of course, they also had a number of friends in the UK. But as can be seen from the memorial services and birthday parties, it was on a much smaller case. There was also some numbers of how many people attended Oppenheimer's 40th and 50th birthday, but those were both outside the assessment periods. Unlike most of the cases to which we were referred, Mr. Oppenheimer did not come to the UK to work. In the years from 2007 to 2010, he worked in and from the UK, doing what he had previously done in and from South Africa, simply because his children's education and his wife's presence in the UK supported that, right? So he was there because his children was going to school there. I mean, they decided to send the children to a UK school as opposed to a South African school. In summary, we agree with Mr. Goldberg that Article 4 of the Double Tax Convention is about relations. And as we have said, that means connections. So he is correct to say that the question that we have to ask is more about who and what rather than when and where. And this also is a bit of a cross-reference to the UN commentaries. While we accept that Mr. Oppenheimer worked in from the UK more than any other country, we are not persuaded that what Mr. Sohn described, so this is the HMRC lawyer, as duties of employment were UK-based after 2012. In no sense could Mr. Oppenheimer really be described as having duties of employment. I mean, the man didn't have to work. After 2012, much of what he described as work was unpaid and self-directed. He could choose what and how he did anything. He traveled a great deal. And if the judge goes through all the things that he do and the foundations and business that he is involved in, and she more or less ends every paragraph with a sentence, and the people that he worked with were in South Africa. Right, and then she said what was important to Mr. Oppenheimer in the relevant period, undoubtedly his wife and his children, but as they would rarely have been out of his thought, we found that South Africa, its people, its culture, its politics, its place in Africa and the world would rarely have been out of his thoughts as well. The same could not be said about the UK. Although, of course, he has friends in the UK, his closer links is with a friendship base with South Africa, and it was interlinked with his various occupations because a lot of his friends were also his business partners. His political interests were closer to South Africa. For all these reasons, we find that throughout the relevant period, Mr. Oppenheimer's personal and economic relations were closer to South Africa than to the UK. And here Oppenheimer already won the case, right? But the judge says, you know, I'm not sure if HMRC appeals, whether the upper tier tribunal will agree with me. So just in case, I'm also going to look at habitual abode, right? And she says, we found habitual abode to be rather more difficult. The commentary at paragraph 19 talks about the frequency, duration, and regularity of stays that are part of the settled routine of an individual's life. Now, the problem is Oppenheimer didn't have much of a settled routine, right? And therefore are more than transient. But, and this is the issue, it also makes explicit that the test will not be satisfied by determining in which state the taxpayer spent the most days. So you need to look more at emotions, I think is what one can say, than simply, you know, hardcore cold counting the days. Mr. Goldberg's starting point was that an habitual abode cannot suddenly cease to be habitual without some acts of abandonment, and Mr. Oppenheimer had certainly never ceased to have an habitual abode in South Africa because he had one before he moved to the UK with the children, and he never abandoned the farms or the friends or the businesses or anything like that, right? The problem with South Africa was whether Mr. Oppenheimer's stays in South Africa were part of a regular order of his life in each tax year, because you've got to look at this by year. The onus of proof lies with Mr. Oppenheimer, and we have no information about how long any stay might have been in 15, 16, 16, 17. We only know that he was not very often there. A further issue with 16, 17 is that at the start of paragraph 19 of the commentary makes it explicit, and this is the UN commentary, I think, that the grounds were there for major, this OECD commentary, makes it explicit that periods where there are major changes of personal circumstances should be excluded, right? And his wife died and things of that. And of course, Mr. Oppenheimer had to be in the US from 17. One of the issues that we have with the case law to which we were referred is that in general those cases deal with binary issues. In this case, Mr. Oppenheimer effectively had homes in the US as well as the UK and RS. And the question is, where was he resident? We certainly do find as and when Mr. Oppenheimer visited South Africa, it would have been part of the regular order of his life to stay at Isibindi or Tswalu. Is that enough? His stays in South Africa could not be described as transient. In the context of his life where he was permanently on the move, the number of days outside of the UK, South Africa was a fixed part of his life. It was not just a fleeting thing, and therefore he did have habitual abodes in South Africa. In the unusual facts of his life in the relevant period, his stays both in South Africa and the UK were both part of the settled routine of his life and were of sufficient frequency, duration and regularity to constitute habitual abodes in both countries. We find that he did have an habitual abode in South Africa and that he is a national of the country. The answer to the tiebreaker is that he is a resident of South Africa. I hope you enjoyed this case. I tried to limit the number of facts as much as possible to stay within a reasonable time, but this is a complex case. It could have gone either way. I think the judge raises some interesting points, and I do like the points about habitual abode, where it is also when you go there, to that country, do you then go to that house, right? And all throughout they had staff employed in both places, and the places were always ready to be visited on a moment's notice. I hope you enjoyed the case, and I look forward to discussing another one with you next week. Bye for now.